You're listening to the Valley Current.
Hey, Bob, welcome into the Valley Current. What's happening with you in Los Gatos?
Thank you.
So that's called the sound. That's called the sound bar. We're taking you into the 21st century here, Bob.
Okay.
There's a microphone and there's a sound bar.
Stupid Microsoft game and forgot to unmute it, and that was the whole problem. But we solved it.
One is called an input, like your mouth, you feed through. And one is called an output, like your ass that you should.
Well, you brilliantly solved it in less than a minute, so let's move on.
Pretty amazing, right? You only have a PhD in geography and a PhD in law. 2 doctorates later, and you can't fix a soundbar.
Well, as a matter of fact, if I were in Germany, because I have 2 doctorates, I'd be referred to as Herr Doctor. And I made my students refer to me as that. It was kind of a kick.
See,
so it's
I knew there was a story. I knew there was a story here. And I want to ask you this. How are you going to get through life in Laos when nobody's there to correct your soundbar for you? How is that going to work?
Why will I? No, there'll be nobody. I'll still be in touch with you. I'll call you up.
Oh,
It'll be an 11-hour time difference. It'll be like 4 a.m. I'll say, Jack, it's 3 p.m. Can you help me out with this little?
Yeah, that's going to work perfectly. I can see you've got it lined up. That's perfect. So let's talk about the Valley Current and how you think there's a topic that we need to publish that for some great reason we haven't been able to publish.
You want the truth?
Yeah.
I'm becoming friends with somebody I knew in law school long ago, and she's interested in this shit.
Great.
And I wanted to send this to her very much, and I've been waiting for like a week and a half.
Okay.
So what's the issue?
So there's a romance brewing, and you're trying to show that you're really a celebrity.
It'll be a funny romance, and who knows if we'll ever be in the same room again.
Well,
or
you like it this way.
So I'm having to be much more patient than I ever have been in my life. But it's just the cards that we're being dealt now.
Well, listen, I want to tell you something. There is an advantage of being in California, even though I agree with you, it's a high-tax state, and I agree with you that there's a lot of congestion, a lot of problems. They benefit, and I hope you take this idea to Laos, serious idea, is if you ride your bike in Palo Alto, you will inevitably pass at least 5 different places you can pick up books for free without paying a dime. Why? Because people are giving away their stuff in Palo Alto in these little boxes called mini library. So wait, you'll love this. It was literally less than 60 seconds of looking. And look at this. No sales tax, no clerk to deal with, no nothing. Beautiful. Watch this. I picked up these books and I thought to myself, Bob would love this. Bob would be like, really? I wonder if I could bring that to us. Breakaway planning. I got this for you. Breakaway planning. This book was a $30 book when it first came out. American Management Association, breakaway planning. Book number 2, how to get referrals. This book was a $26 book when it first came out. Paperback, $26 book. Number 4. The universe has your back.
Oh, she's cute.
Nice looking woman, right?
Yes.
Universe has your back. 1995. I want to add this up. How to starve cancer. Not that I have cancer, but in case I get cancer, I can now learn how to starve cancer. $25.99. Are you with me? That's $100, almost $100. And then if you're getting ready to die or someone's going to die around you, which my brother might be doing this week.
Yes, what's going on with that?
Richie, remember Richie? Richie Russo?
I know. He weighs 400 pounds, and so he's not in the best of shape.
He's lost 150 pounds, Bob. He's down to 240.
But it's not comparable to my situation exactly.
Okay.
He may be a wastrel and a hanger-on and a this and a that, but he's not. So it's not quite the same thing. So I dare say you're more into it than I would be in with my SIB.
Yep, $114 worth of books. So there you go. Literally less than 60 seconds passing by the little bookstore. And I said, this is the land of plenty, man. You can't beat this place. I mean, you can't beat California away. But let's turn to the topic at hand, because you have a love interest that you have to send a copy of this to. So let's start here.
So is that going to happen?
Yeah, well, we're gonna do a podcast right now.
Oh, right now. I mean the VisiCorp one. No, this will be fun too.
Yeah, no, let's turn to the topic at hand, and I'll figure out what's going on.
Yes, let's do that.
Right. So tell us what we're going to talk about.
We're going to talk about two parts of Irvin Younger. You're going to focus on the 10 rules of cross-examination. I'm then going to follow with the 9 ways of impeachment. Logically, right. It's possible you could argue that mine should come first, but I have this whole dramatic conclusion worked out. So I think you should go first, and again, reserve maybe 8 to 10 minutes at the end for me.
Are you sure that you shouldn't go first? Because yours might be more popular than the 10 Commandments.
I'm not saying it'll be more popular. It just has more of a dramatic flair to it at the end.
Okay, so let's start with a snippet from Irvin Younger, which I think is very valuable. So Irvin Younger was a very, very, very important guy in my life, and to some degree, maybe to a big degree, yours as well, because he was a New Yorker who also was on the bench, and he was a very, very important person talking about and teaching cross-examination. And his lectures are brilliant, and many of them are actually still available on YouTube. Very well done. And of course, unfortunately, he died a very young life. I think he died at the age of 56 or so. He was on the bench for like 6.5 years or 5.5 years. He was a New York trial lawyer, a professor in the later part of his life. And he started to be a professor. I actually think he started kind of at a time when video recording was just starting. So we're talking like late 60s, maybe early 70s. So I want to put on an excerpt, a short excerpt about his 10 commandments of cross-examination. I want to spend a few minutes talking about it, but Bob, you want to spend a few minutes then talking about kind of his impeachment stuff, right?
The 9 rules of impeachment. I want to talk about it because although I haven't heard this lecture in, I would say 40 years, yet of the 9 rules, I could quote verbatim 6 of them. He's just a brilliant, brilliant speaker. And I want to give a little recap of what he had to say about the 9 rules of impeachment.
Yes, but let's hold that because we're going to do Irvin Younger's 10 Commandments. And this is a video, and I'm going to turn the video on because I think it's very, very effective to use even just this 3 minutes of Irvin Younger. So just hang on a second. Let me just get it queued up here because I didn't have it perfectly ready. But now I'll cue it up. Just hang on a second. And of course, these videos are now sold, but they put snippets available online as a way to help people understand what's there.
How do you do it? We understand what to ask about, reference to the law of evidence. How to ask the questions.
Notice the bow tie.
I have come up with a set of suggestions, guidelines, if you will, which if made part of your intellectual repertory and made to become second nature, will guarantee, and I am choosing my word carefully, will guarantee that every cross-examination you conduct is reasonably competent. It will not be a flash of lightning. No, it's not going to be Clarence Darrow. No, but you will never humiliate yourself. You will never throw the case away on cross-examination. So desperate am I that everybody achieved that really minimum level of professional competence that I withdraw here and now my designation of these things as guidelines or suggestions. They are not guidelines or suggestions. They are commandments in the sense that you must follow them.
Very New Yorkish.
Do not. If you violate them, you will pay the price. You all know how many there are because they're listed in the outline. There are 10 of them. But because we've been together all day and start to be friends, I wish to make a confession. There really aren't 10. There are only 6 or 7. But I say some of them in different words to make it add up to 10. Because 10 Commandments has a literary ring that I find appealing.
Notice how big the microphone is.
Especially towards the end, if
with the bow tie.
Be repeating myself. Do not rise in your places and denounce me. I know that I'm repeating myself in order to get it up to 10. I have struggled to reduce each commandment to the fewest possible words. It's a matter of a half an hour to memorize the 10 Commandments, probably less. Probably many of you know them already. I tell you from harsh experience that to know them in the sense of being able to write them down 1 through 10 is not to have made them part of one's intellectual repertory. You must school yourself to cross-examine in accordance with these commandments. At the beginning, irresistible temptation is to violate the commandments. You've got to make yourself do it in accordance with these commandments. If you're about to hear them for the first time, I guarantee that the next time you cross-examine a witness, you're not going to do it any better than the last time you did it. But this time, as you violate the commandments, you will know that you're violating the commandments. You will know which commandment you are violating. You will realize that with some questions, you violate all 10 commandments. Question, but you somehow can't help yourself. It comes out that way. But the next time around, and the next time around, it gets to be a little bit easier. And by the 25th jury trial, you don't have to think about it anymore. And then, well, you've reached that level.
Better go back to live.
So that's the introduction to the 10 Commandments. And then there's actually a 50-minute or so overall presentation. That's the short version. The short version is 50 minutes, in which he goes through the 10 and he talks about be brief. In other words, he makes a point that cross-examinations that work get to the point quickly and are like commando raids. They go in, they fire, they kill the criminal or kill the defendant, and then they're over. And he goes through the other 9, and in fact, there's some repetition, but he goes through each and every one. It must be a leading question. You cannot ask what happened next. You must ask, this is what happened next. And isn't that right, sir? Isn't that correct, sir? And he goes through each of the 10, and he illustrates in a very funny way. And we could play the 40 minutes, but it wouldn't really be fair because we want to comment on most lawyers most of the time have not even heard of Irvin Younger. They have no foggy idea of what they're doing on cross-examination because they don't understand that the whole point of a trial is to make a closing statement that persuades a judge and or jury, typically a jury and a judge approving as the 13th juror. A lot of lawyers don't even know there's like 12 jurors in state court and 6 jurors in federal court. They don't know because most lawyers...
Let me put in with a question, Jack. Do you alter your strategy on cross when you have a bench trial as opposed to a jury trial?
Absolutely, because judges are way more savvy of what I'll call the inference. So if I say to you, Dr. Acker, isn't it the case that you are pursuing a love interest in a distant jurisdiction? I could stop there. I don't have to say she's female. I don't have to say she's someone you've been thinking about for many years. I don't have to build a colorful picture. The judge just gets the point that you're aroused by some female. They get it. The judges get it. Female or male judges get it. Sorry?
Stop the presses. Aroused by a female. What next?
But that's the point. The point is that judges can listen between the lines. You'd be amazed. A lot of judges will say, send me the exhibits in advance of the trial. And the lawyers are like, some lawyers are like, no, I don't want to do that. I want to do it the old way. And the judge is like, are you effing crazy? Like they really don't want to curse because there's a record. I want to read the exhibits. So, you know, when you arrange a book of exhibits, as I do every day of the week, it seems like there's another book of exhibits. Like they're always stacked here. And I got a book of exhibits. I'll give you an example. So here's a book of exhibits, right? There's like 50 exhibits in here, right? In this book, right? All right. When you read those exhibits from exhibit 1 to 50, you don't think the judge is going to start to understand the case? Of course the judge is going to start to understand the case. He's going to say, you guys entered an agreement. I see the agreement. I see signatures on it. I see some accounting statement saying that money, commissions, whatever, stock, whatever was paid. I see that. Then all of a sudden everything stops, but I don't see a notice of termination. I don't see a notice of breach. I don't see you committed a crime. You're in jail. You can't perform. I don't see that. I just see an abrupt stop. Like, what the hell happened here? Now I'm aroused. I'm aroused. It looks like a lot of money was, you guys were making money together. What happened? You had a marriage. What does the judge think? They start thinking instantly, you were married by this agreement. It was like a marriage contract. You were married. All of a sudden, I don't see the divorce papers. I don't see the termination agreement. I don't see a settlement agreement. I see an abrupt F you, stop. Now I'm aroused. I want to know the story. And you know, if you're a good plaintiff's lawyer, you make sure by the end of that 50 exhibits that you submitted, that judge is aroused and wants the answer to that question. He's coming in that trial wanting to know, what happened here? This looks like a marriage. This is what makes California great, the United States great. You guys did a business deal that made a lot of money together. What happened? And a jury, they don't have the foggiest idea. They haven't seen those 50 exhibits. They don't even know if the case is going to be a personal injury case that morning. They don't know if it could be a criminal case. They're downstairs. I say to young lawyers, the first thing I say to young lawyers here at this firm, we're going to go sit in the jury pool downstairs in either San Francisco or San Jose. They look at me like I'm crazy. I said, let's sit here for an hour and watch what happens. People come in, they check in, open public space. People are on their phones. They give Wi-Fi now. Some people are talking on the phone. And every one of them is pissed off. P.O. Why? Because I have to sit here because of some civic duty because I have a driver's license in California? I'm going to waste the whole afternoon. Some of them are on the phone trying to get deals done. They're salespeople. And they go into that courtroom upset that they were ever called. So when you're long-winded as a lawyer, they're like, and then this guy is going to tell me that I don't know what a commission agreement is? And he's going to explain to me there's a piece of paper and it's got a signature on it. You know, judges, you can just get right to the point. You're going to send the exhibits to them, you know, right off the bat. Some of them require that you send them direct testimony in writing off the bat. They don't even want to hear the direct testimony. They're like, it's all scripted anyway. Send me the declaration. Send me the PowerPoint. They're like, send me the summary. Send me the summary of the deposition. You guys should exchange the summary of the deposition. I'm not reading any 200-page deposition. Send me the 5-page summary of the deposition. What's this client going to say? Make an offer of proof. So yeah, there's big differences, and there's big differences with jurors. A juror that walks in with an attaché case wearing a 3-piece suit who thinks he should be earning $600 an hour because he happens to be some sort of highfalutin executive, and he's really pissed that he's there, that's going to be a different juror than the retired postman that's like, hey, man, this is entertaining. Or postwoman. This is really entertaining. I could be here for 3 weeks. And you know it immediately because the minute that one of those jurors raises their hand and says, Your Honor, and this is the typical out, so people should get this. What's the out by a male juror? Your Honor, I've got a prostate problem. I can't sit without going to the bathroom every 30, 40 minutes. You're going to be very upset with me. I don't want to tell the rest of the jurors that. Can I whisper that in your ear? I've had that problem for a while. I can get you a medical note. You don't think some judge in his 60s is going to understand that, male or female? And what if you're a woman juror? Your Honor, right now I'm going through my period. I know it's that time of the month. I'm going to be in a lot of pain. Maybe next month you call me again, put me in the lottery, and then she changes her driver's license by changing to a different county because she's got a summer friend that has a place up in Marin County, and she uses that as her just. People get out of, the really good jurors get out of jury duty a million different ways, in my opinion. No derogatory statement about other jurors. But you are pitching to people that mostly don't want to be there. So if you can't follow these rules, of which we'll do a more detailed version rule by rule, but the first one, be brief, people violate that all the time. We used to see it at Davis, Stafford, Kelman, and Fenwick. Even the great lawyers there, we'd say, you know, if you ever said to Ed Gregorian, bless his soul, tell me about the case, you'd have to be ready for like a 30-minute lecture from Ed about some case. Nice guy, smart guy.
That's what we discussed last time, the 200-plus exhibits and that. I mean, the jury must have died by the time.
I thought at the end of the day.
I mean, they're just jurors. They don't want a postgraduate education.
Exactly, but let's face it. If you're Ed and you've been trained in the white shoe, white and case, New York style litigation, in his head, he is building the encyclopedia He wants to make sure every volume of that encyclopedia, I mean, your library, what did it have, 8,000 volumes in it, your library?
It had 3 before I destroyed it, yeah.
Yeah, you had a huge,
yeah.
you had a ginormous library. You had the biggest personal library that I'm aware of, and I'm aware of a lot of libraries in this United States, in the world, globally. You had one of the biggest personal, single person, because your wife died, so single person. It's not 2 people sharing a library. That was your library, your individual library. Probably had a few of Bonnie's books too, but mostly your library. Most people in the United States have a library of about 10 books. Yeah. And most of them are cookbooks. Most of them are cookbooks. You had stuff that you can't find. You had like the original version of like the Rise and Fall of the
I had
Third
a good
Reich.
library. I gave about 1,000 books away to the Oakland Library as I was moving out of my Oakland address. I shipped most of the rest to Laos. They're now, held up in transit, just as I am. But there's still a good 1,500 to 2,000 left if I ever get there.
And I'm saying to you, one of the things you should do, and the idea that came to me was because I was riding my bike, passing all these little mailbox things. You should bring that to Laos. That will make a big permanent difference. You should say the Bonnie and Robert Acker sub-library or mini library. What do you want?
That's the idea. That's the idea.
Great idea.
No, I mean, some of course I want. And I don't think the Lao people are really interested in the wit and wisdom of P.G. Wodehouse. I mean, that's really for an English speaker. But lots of them are going to go into their library.
I think that you'd be amazed at people picking up books that have the foggiest idea whether it's going to interest them. And then all of a sudden it's like, wow, I had no idea. A book is like an adventure. A book is like taking your mind. I mean, people talk about virtual reality and putting on glasses and going somewhere else. If you know how to read and read fast enough to actually get through a book so you're not bored by the time you open and close it. We started with these books. If you open and close a book, you got to be able to read it fast enough to get the gist of what that author was saying. You could rewrite the book by the time you're done, but don't give up on it because there's usually something that's very special by the time the journey ends if the author did a halfway decent job, which usually means the publisher wouldn't publish them if they didn't. So let's turn to your topic because we have at least 10 minutes left, and we'll go through
let me
them
just
in
go
more
through
depth.
the 9 rules of impeaching a witness, all found in the Federal Rules of Evidence. And basically, I'll just briefly list them and then give my little presentation.
Yes.
There are 2 groups of 4. The first group of 4 has to do with the competence of the witness. Did the witness understand the oath that he took? Was the witness a precipient witness of the events about which he testified? Did the witness remember and is able to remember these events? And is he able to recount them? So
Yes.
Those are the 4 competence. Then there's a sort of odd one about does the witness have a good or bad reputation for truth-telling in his neighborhood? Then there's 4 having to do with the credibility of the witness. First, is the witness biased or prejudiced against the parties? Or has the witness been bribed to give his testimony? Second, has the witness been convicted of a crime? Third, has the witness made a prior inconsistent statement that contradicts his testimony? And last, has the witness committed other prior bad acts? Okay, so there are various wrinkles that I'm not going to go into now because what I really wanted to say was when Irvin Younger gave this lecture, he had this dream in which the witness was impeached in every one of these 9 ways at once, bang, 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 like this. What? Now, Mr. Witness, do you understand the oath? Isn't it true that you have no comprehension? Well, yes, now that you mention it, I was taught the oath by a parrot. I have no idea what it means. And isn't it true that you didn't actually see any of the events that you testified about? Well, yes, now that I must admit that I was climbing Mount Fuji at the time. So how the hell could I have? And isn't it true that you have a defective memory and have no ability to recount things? Well, now that you mention it, I have to say that my memory is the despair of everybody who knows me. I don't even know what this question's about. And isn't the fact that you have no ability to understand communications in the English language? Yes, I must admit that English is just a closed book to me. Isn't it true that the neighborhood children yell and scream, liar, liar, pants on fire whenever they see you? Yes, and in fact, the little try to set fire to my pants every time I see them. And isn't it true, Mr. Witness, that you hate the plaintiff's guts and would do anything to destroy him? Yes, by any means, fair or foul, I will do him in. And isn't it true, Mr. Witness, that you know the defendant? Yeah, well, yes, she's my mom. And isn't it true that she bribed you to give this testimony? Well, she did say she'd triple my allowance. And isn't it true that you've been convicted of perjury? Well, it's true. I've been convicted of perjury 5 times. It's so much fun, I just can't help myself. I now show you this full-page ad in today's New York Times. Didn't you place this ad in the Times? Well, yes, I must admit I did. And doesn't it contradict every single thing you just said? Well, if you want to get technical, I suppose so. And finally, Mr. Witness, isn't it true that you've committed perjury, that you committed sodomy with a parrot just last night? Well, now that you mention it, yes, I had to do that to get him to teach me the oath.
Yeah.
So that's the dream cross-examination of impeaching a witness.
But, you know, he does this as a way to sort of say these rules are rules that are meant to apply and be memorized. And he tells these stories to really act as a mnemonic, because a lot of people just can't get checklists to be part of their repertoire. And he really wants students to know that there is a repertoire, and good trial lawyers have this innate ability to know the commandments and know these rules. So let's just spend a second, because I found the black and white version. So this is really old, but these are the 9 pigeonholes. He calls it 9 pigeonholes, but he's referring really to what you just said, because you just made the point that these are actually the pigeonholes that apply to learning and understanding these rules of evidence and how they operate. So let's cue this up and see if we can get this to go. Let's see if it goes. Yeah, hold on a second. It actually runs for 48 minutes, as does the other one about the 10 commandments, and we're only taking snippets out of each.
Never violate these commandments.
In the summer of 1974, I heard one of the greatest lectures on trial practice I've ever heard anywhere. The lecture was delivered from the top of a mountain overlooking Boulder, Colorado, during the course of the National Institute for Trial Advocacy. The speaker, Professor Irvin Younger, his subject, the art of cross-examination. I'm Bob Hanley, and I'm chairman of the section of litigation of the American Bar Association. When I heard that lecture on the top of that mountain, I knew that somehow I had to get it to you, the American trial lawyer. We talked Irv off the mountain and onto the podium at Montreal, where he delivered his reprise of his Sermon on the Mount. Happily, you're going to be able to hear it very soon. Irv Younger is an outstanding trial lawyer. He's a former district attorney in New York. He served as a state court trial judge. He was on the faculty at New York University School of Law. And today he holds the Samuel S. Leibowitz professorship in trial practice at Cornell University. Irv expends unbelievable amounts of time and energy trying to make better trial lawyers out of all of us. This section of litigation is very proud and very happy to be able to present to you Professor Irvin Younger on the art of cross-examination.
Okay, I hope I have the right thing. I called it 9 pigeonholes, but maybe I don't have the right thing. I thought this was the impeachment stuff. We're going to see. If it isn't, we'll have to do it a different time.
Ladies and gentlemen, your planning committee was so rash as to give me an entire morning to talk about cross-examination. But it's not enough. Cross-examination is so complicated, there's so much to say, that we can't possibly do the subject justice in just a morning.
It's not the 9, right?
I'm going to be talking about only one kind of cross-examination.
Wait. This might be good.
Now, let me take a moment to mention a couple of the kinds of cross-examinations I will not be discussing. There will be occasions when a trial lawyer wants to cross-examine a witness so as to persuade the jury that the witness is worth believing. I'm not talking about that kind of cross-examination. There will be occasions when a trial lawyer wants to cross-examine a witness so as to convey to the jury some impression of the cross-examiner's theory of the case. I'm not talking about that kind of cross-examination. The kind of cross-examination I will be talking about is the one that's probably most commonly encountered in the courtroom and probably the most difficult to do. It's what I call destructive cross-examination. Cross-examination whose purpose is to persuade the jury that the witness is not worth believing. You might also call it impeaching the witness or discrediting the witness. That's all we'll be discussing this morning.
I'm going to zip to the end just to see where he goes with it because we have very little time. This runs about 48 minutes. I'm going to just zip over to sort of the last minute of it just to see if this ends more on cross-examination. Oops. Of course, you never quite get this right, unfortunately. Oh, brother, where did it go?
You do these things in advance. I've learned that.
Well, yeah, and I didn't have the time to do it, so you're right. It's my bad here. So I want to get to the end of that video, and it's probably not going to be queued up on time. But when you think about the impeachment stuff that you were talking about, Bob, do you think it was actually something that was taught, say, at our previous firm? Because
I know it wasn't, because if it had been, it would have been taught in evidence. And I know for a fact it was not taught in evidence. So no.
In law school, you mean? You're going to law school?
Yeah.
I'm actually talking about in the practice of law, because we teach people.
Oh, you mean did Ed Gregorian teach me or any of the other people in the firm when I was a young lawyer?
Right.
No.
Right. And that's the point that I'm making, which is a lot of people.
There were weekly teas, if you remember, at the firm, and there was sort of hints of it, but no, not in any systematic way.
Right. I mean, I think of it as when you go to a big firm, they pretend like you're going to get this great education. And it wasn't a big firm we were there. It was still a small firm. But the truth is that the reality of the situation is that you have to get on-the-job training in the way in which you're going to do the work that you're going to do by trying cases. It's a lot of trial and error. It's a lot of error. I guess it's probably a lot of error is what you would say. But it's a lot of trial and error. And that's why his point of 25 trials is so important, because the reality is you have to see how badly you get hosed by witnesses. There are some really, really sophisticated witnesses that know how to take advantage of you, particularly expert witnesses. It's really amazing how expert witnesses can essentially make your life difficult, if not literally impossible. So I like to think of it as what he's doing is trying to give people aid in a subject that really is hard to do unless you're doing it experientially, like a lot of criminal cases, or like Daryl Nelson, my original partner and your good friend. And what does she have, like 650 trials under her belt, something like that? By time
it must be very different. I mean, how long did it take you to get to 25, let alone 650?
Well, she was doing multiple cases every day, right? She would do 3 a day, she would tell me. She talked about.
Well, that's all they did. I mean, barristers only do trial practice. So yes.
Right. So barristers don't do any of the paperwork. They don't worry about fee agreements.
What about witness prep? I really don't know.
They don't touch witnesses. There is no preparation of witnesses. It's illegal.
So all they do is go into court with having been briefed by the solicitor, and that's it. So all she did was trial work.
What she would talk about is she would get a file, like she would get essentially a batch of paper handed to her, be at this courthouse by 1 p.m. after lunch. You're going to defend this person who raped this girl. And she would read the papers on the train. She would talk about reading the papers on the train. It might be some court outside of London. And she would show up and say, oh, Miss Daryl Truella is here from the big city. The big city barrister is here. Okay, Miss Truella, here's your defendant in the dock. No discussion with the defendant. No discussion with any of the witnesses. And literally has to go through and work on how am I going to impeach that witness? What is the closing argument going to be? And the main point that he really makes that we didn't go through is if you haven't figured out what your closing argument is, you have not figured out a way to get the case ready. And you have to start with the closing argument in mind. You have to think about what is going to persuade, whether it's the judge, the jury, the arbitrator, the mediator, or even the opposing counsel, because a lot of cases get negotiated. We know that 90% of the cases get negotiated. Maybe 95% of the cases get negotiated.
Easily, way over 90, certainly over 90, yeah.
And so a lot of cases, it's really about what's going to convince the opposing party. What's going to get the opposing party to believe in something or not believe in something? Because that's what you're doing. You're trying to get the opposing party to see your point of view. And unfortunately, lawyers don't get along very well, so they can't even do this in a nice way. Let me put this on. Let me try to line this up.
That deficient evidence is the certified or exemplified judgment of conviction. Do it by the record. In theory,
I'm putting it on. Hopefully this works. Let's see what he does with this.
you can do it in other ways. Call the foreman of the jury that found him guilty. Call the judge. Call the clerk of the court. We will not spend the time on that. You've got to do it by the judgment of conviction. Now, the third, prior bad acts. Not a conviction, but some prior act by the witness of an immoral, criminal, or vicious nature. Not every jurisdiction permits this mode of impeachment, but a majority do. For example, the witness has on a direct examination that the traffic light was green. Mr. Witness, did you beat your wife last night? Or do you commit sodomy with a parent? Or whatever it may be. These acts did not crystallize in a conviction, but they're of an immoral, criminal, or vicious nature, and in a majority of the courts, you will be permitted to question the witness about them on the theory that it does have a bearing upon credibility. In those jurisdictions which allow it, it is collateral, meaning you may ask the question, but if the witness denies it, you've got to take the answer. You will not be permitted to call other witnesses to say, yes, he did beat his wife, or whatever it may be. The reasoning there is that while the question has enough of a relationship to credibility to render the question permissible, the relationship to credibility is so slight that we will not spend the time listening to this independent evidence to show that the denial was false. Again, because of the pressures of time, let's move on. Number 4. Perhaps the most commonly used mode of impeachment, and perhaps the simplest. Nobody in this audience is confused about it, but trial lawyers whom I used to see trying cases back home in New York City generally knew that there was such a mode of impeachment, but they didn't have at their fingertips the ability to use this mode of impeachment crisply and elegantly. And that's what you want, of course. What is this mode of impeachment? Prior inconsistent statement. You know how common it is. Use it 3 times a day in your own practice. The witness says on direct examination that the light was green. We are now going to put before the jury a prior statement by the witness in which he says that the light was red. What's the impeaching value of it? Well, it's obvious. The witness talks out of both sides of his mouth, talks with a forked tongue, therefore he's not worth believing. Says one thing today, another thing back then. In theory, that's all there is to say about this mode of impeachment. It's very common, it can be very potent. Why is it that there's such confusion, such lack of elegance in using it? Because in most jurisdictions, there is a preliminary requirement which must be met before you can impeach with a prior inconsistent statement. And the tag name for that preliminary requirement is what? You will recall your early days at the bar. You set out to impeach a witness with a prior inconsistent statement. The lawyer on the other side jumped up and said, I object. No foundation. The judge said, objection sustained. Well, what are they talking about? Right? If you had the guts, you'd say to the judge, Judge, help me. Right?
So unfortunately, that's where it stops, because what they did is they batched together his cross-examination stuff with his impeachment stuff, and I got to find the impeachment.
Okay, just in case somebody in the audience doesn't know what he's talking about, lay a foundation means you confront the witness with the prior inconsistent statement, which is why I brought in that business about the full-page ad in the Times.
Right.
Is it that, I mean, that's all that's meant by that.
So the point is that lawyers need to learn how to be good bricklayers, and each brick is itself an element. And it goes back to the early question you raised. With judges, you could put the whole wall up quickly. You don't need to go brick by brick, because judges get it. This is a commercial relationship. There's a written contract. I see signatures. It looks like there's performance. I don't see anything wrong. They were married. I'm waiting for the punchline. I'm already there in the 7th inning. We don't have to spend a lot of time with preliminaries. With jurors, you have to start with, this person's a human being. They breathe. They eat. They negotiate. This person's a human being. he breathes, not a robot. They started negotiating. They did this contract. It takes you like 30 minutes to just explain what a contract is, because you can't assume the postal worker knows, although most postal workers do know. You can't assume that the household husband or the household wife necessarily knows. Maybe they know, maybe they don't. But judges know, because they're dealing with it every day of the week with summary judgments and everything else. That most judges have been lawyers, so they know what's going on. So yeah, there's very different approaches between judges and juries, and very different approaches based on things like time limits, which in the federal courts have become, you're going to get a time limit. You're going to do a $100 million patent case in 25 hours, divide up the time, 12 each and an hour for closing argument. And we'll figure out how we're going to split that based on what's stipulated and what isn't stipulated. Like, what? 12 hours each? I got a $200 million case here. Yeah, maybe I'll give you an extra hour if you really run out of time. And, judges are getting strict with time, and it's hurting. It's having a real impact. Most state courts, they don't do that, but they're going to start doing that. They're definitely going to start doing it, because lawyers tend to take a long time. They're not brief. They're not to the point. They upset a lot of judges with how much time they waste, and they don't cooperate with each other.
So let me ask you another question. I know that you have a strong interest in clarity and concision. Is it tactical because you have to confront judges who are going to hold you to the time limit, or is it more a matter of aesthetics and good taste? Just present things clearly, for God's sake.
Yeah, look, what we do in most cases that a lot of lawyers don't do anymore is we actually get these blow-ups. Like, I'll actually spend some money. This one was just kind of a goofy thing to do, because we ran this tombstone that says Jack Russo's been in practice for 40 years. And we put it on a blow up, but it's not really a big blow up. A big blow up would be like 4 times the sizes. But let's say you have a page of a contract that's really critical. You get something like this blown up, and you bring it in the court like it's a picture, like it's something that's worth looking at. I mean, an example I'll give you that you'll appreciate, and maybe you'll send the video to your future wife, and she'll appreciate. Take a look at this and tell me what you see. I hope you're able to see this.
Actually, I see someone whose face is turned away from me. I'm guessing it's a female. It looks like some sort of hat with a white scarf covering the rear left of her head, and she's wearing some sort of brown dress or cloak.
Right.
And something beautiful around her neck that matches.
This is her nose, right? She looks beautiful, right?
I'm guessing, yeah. And that her left ear is...
The nose is down there, and her chin is here, and this is actually her lips. What do you see then?
Oh, yeah, gotcha. Now it looks like the man in the moon. Now it looks like the crescent man in the moon.
Right.
With a little slit mouth and
This is a typical optical illusion where you could either see the beautiful woman whose hair is up here, and this is her necklace, and this is her nose, or the chin is down here, and it's an awful looking woman with a ginormous nose, right?
Yeah, I guess it must be a woman because the white scarf is still there. So, right. Yeah.
So the point is that, different people see a set of facts or see an image.
I remember one account of a case. It was in a Midwestern state in which the jury went off on basically moralizing. Well, I got the feeling the defendant didn't really care about other people, so I dinged him for $1.2 billion. I mean, the facts had like nothing to do with it. It was amazing.
I think that a young lawyer in my office that was second chairing a case, she said, Jack, we're never going to win. We're never going to get attorney's fees. Well, I'm overstating it. She said, I don't feel good about this case. We just got the verdict in. It was $1.4 million in damages plus, and this was tried in front of a judge, plus attorney's fees plus, and we didn't think we were going to get it. We got like punitive damages from a judge, and judges are very reluctant to issue punitive damages. And we just got the detailed written ruling, a case we tried. And it's like, it was her first 7-figure trial. So she's really happy because, it allows her to say to all of her friends, I got to be part of a case where we won 7 figures. There aren't that many as people think. To get a 7-figure case, meaning you got to do the work to get there. To get an 8-figure case, that's even better. There's very few 9-figure cases, and I think there's only one per year 10-figure case where you actually get a verdict for 10 figures. It's such a substantial thing. So conceptually, it's really a different story. in terms of what convinces and what doesn't convince. And I have to say, Irvin Younger, he died too young, because if he were still alive, he'd probably be in his 90s now. I think he would say the trial system is so broken, the time limits are so wrong. He would go through a lot of things that he didn't like. He would get judges to sort of get rid of all the administrative side of the work, where they're just managing case management. He would put that in front of paralegals. That's what I think, right?
Yeah, we've run a little over anyway, so that would be fine. So thanks for this fun time, and I'll see you next time I see you.
Yeah, you look good, Bob. So it looks like the modem worked. The thing I gave you worked better, right?
Yes, I'm probably almost out of time on it, so it just fit.
Good, great.
Yeah.
Talk to you later. Take care. I'll
Good.
send you this to send to your love interest.
Yeah.
Tune in next time on The Valley Current.